Well, thank you, everybody, and welcome to the Legal Table. I'm your host, Crystal Jamerson, and I'm the Community Engagement and Outreach Coordinator for Legal Services of Northwest Minnesota. The Legal Table was created to educate you on your rights and responsibilities, along with introduce you to the community organizations that have resources to help you along the way. Today, we're going to be talking about money and debt in Minnesota. We chose this topic because as we're headed into the holiday season, we know that many people tend to overspend, often unintentionally, and then spend months trying to dig themselves out of debt. And it's not just about the holiday season, too, it's throughout the year. Today's conversation will just touch base on the challenges and offer some practical guidance as far as your legal debt and money. We'll be hearing from our experts about issues like medical debt, bankruptcy, and garnishment struggles that many people face, particularly during and after the holidays as well. Our goal is to provide information, resources, and hope for those dealing with these burdens. So we're definitely glad to have you today. Presently, we're trying to make sure that with the legal table, we're able to reach people in counties that are underserved. Also, we want people to be aware of the options and resources available for the community members specifically. As you know, Legal Services of Northwest Minnesota, we serve 22 counties and we have 3 offices in the area where we assist clients in navigating the justice system and provide services for low-income individuals with their civil legal needs. Outside of providing like full representation for a client, we have legal kiosks in about 87 locations in our service area that provide assistance with virtual courts and legal documents. We have a justice bus, which is our mobile clinic, and that allows us to go into communities where transportation is limited to provide legal assistance. We also have self-help clinics with the do-it-yourself type of court forms, and we hope to bring you just any type of information on civil legal topics throughout the year. So make sure you to continue to join us and pass the information along to coworkers and clients. With that being said, I want to introduce you to our special guest today. We have Kevin Carell from LSNM, Legal Services Northwest Minnesota. We have Beth Goodall from Mid Minnesota Legal Aid. And we have Cheryl Bergian from Cheryl Bergian Law. Real quick, also, I want to make sure that we have just a few house rules. Please make sure to put all of the questions that you have in the chat and we'll get to them at the end of the presentation. We do this so that we can allow all the presenters to be able to have the adequate amount of time to present. Also, this is a quick hour-long meeting, so if you'd like more information, each panelist will have their information at the end of their presentation. And this meeting will be also available on our YouTube channel by the end of each week. So if you have coworkers or are unable to make it, please make sure to check out our channel. This particular legal table, we are applying for 1 standard CLE credit. So make sure that you check out your emails afterwards if you are looking for a CLE credit, and you will have the little course code on there to be able to get your CLEs. And without further ado, we are going to go ahead and get started. So I will turn the mic over to Kevin and I'll stop sharing my screen.
Perfect. Well, thank you, Crystal, and thank you everyone for joining us this afternoon to get some valuable information about money and debt in Minnesota. And whether you're watching live right now or watching a recording of this, we just appreciate you taking the time to dive into these important issues. So with that being said, I'm going to just jump right into it. I'm going to start sharing my screen and pull up the PowerPoint that I've prepared for today. So what I'm going to be talking to you about this afternoon is the issue of medical debt, and specifically when you're facing a lawsuit over the medical debt, that you're going to be sued by the medical provider over. So a couple things that I want to touch on first, just generally is medical debt. It's a growing problem in the country. At least thousands of Minnesotans are facing medical debt that they're living with. Millions of Americans are facing similar issues nationwide. Living with a significant amount of medical debt, it can really impact a lot of areas of your life. It can make it difficult to afford housing, to pay for essential things like childcare or additional medical care. And it can sometimes even result in your wages from employment being garnished or money even garnished from your bank account. So if you take away nothing else from this presentation, what I want to make clear is that if you do receive any kind of documents letting you know that you're being sued over medical debt, it's very important to take it seriously, and it's not the kind of problem that's going to go away by ignoring it. So make sure that you're, really looking at what's being said in the documents. Make sure that you take a look and make sure that everything's accurate. And you also are going to want to consult an attorney if possible to make sure that you're getting the best advice and information possible. Which is one of the areas that I practice in is, when people are being sued for medical debt, we can at least give them a consultation. And sometimes if there's defenses, we might even be able to step in for full representation. So the first question that you're going to want to answer is how do you know that you're being sued for medical debt? Um, Obviously, you're going to be served with paperwork to start a lawsuit. And the papers that you're going to be served with, they're called the summons and complaint. So they might include language like you are being sued or language to that effect. And they're also probably going to have information about the amount of money that the person that's suing you, person or entity that's suing you, is claiming that you owe. And then it's also going to indicate how you should go about responding to the complaint. Usually, you have a 21-day time period from the date that it's served on you to give a written response to the party that's suing you. Another thing I want to mention is sometimes if the amount is less than $20,000, it might be something that's not happening in state district court. You might actually be sued in small claims court, sometimes called conciliation court. So there's just a little bit of a difference there, in terms of how the lawsuit moves forward. Another thing I want to mention is that sometimes you may not recognize the company or entity that's suing you for the medical debt. And the reason for that is because sometimes hospitals or other healthcare providers, they will sell your debt to a debt collector whose job it is to go about collecting on the amount that you owe. So it might actually be a different entity than the healthcare company that you got the treatment at that ends up suing you for the medical debt. So, it might be a little bit confusing because you might see a different company name. That doesn't mean that, the debt doesn't exist or it's made up. You do want to verify those things first to make sure that it's not some kind of scam. But often it isn't the healthcare company that you got the medical treatment for. And for those of you that don't know, the reason that these companies would sue you would be in order to obtain what's called a judgment. A judgment is basically just a court order that says that you owe a certain amount of money. And that's the reason that they bring the lawsuit, is to get that court order to then attempt to enforce it against you by collecting on it. So a little bit about service of process. Part of the process of a lawsuit is that there's specific rules about how those documents that I mentioned in the last slide, the summons and complaint, need to be served on the defendant or the person that's being sued. So these requirements, they're called service of process. Typically, what the Minnesota Rules of Civil Procedure say is that the party that's suing you actually has to have someone physically hand you the documents or leave them at your residence with someone who's an adult and, is legally competent. If they don't do this, like for example, if they send you the documents in the mail or they tape them to your door, that may not be sufficient service of process, and that might be a defense that you could raise in the case in order to get it thrown out. Another thing you want to keep your eye out for is sometimes the company that's suing you might mail you the documents, the summons and complaint that I mentioned, and they might include with it a document called a waiver of service of process. So this would be something that you would sign, just saying that it's okay that that it was sent in the mail, which doesn't actually, meet those requirements. But you're still agreeing that that's proper service. So keep an eye out for that. You do not have to agree to that. So that's something to keep in mind to make sure that they're serving you properly to begin the lawsuit. So now I just want to get into a couple of different potential defenses. There's many defenses that I won't have time to get into here. There's just so many of them, and there's a lot of complexity to a lot of them. So I just chose two. These are some potential situations where maybe you could get the amount that you're being sued for reduced or get the lawsuit dismissed altogether. So the first one is Minnesota statute section 62Q.75. So basically what this defense is about is there's requirements for healthcare companies when you get treatment with them to submit their billing to your insurance company within a certain time period. This is one of those either or laws. So basically what it says is within 6 months of the date that you got treatment, and that's if the healthcare provider, the hospital, the clinic that you went to, the pharmacy, if they're aware of your health insurance information within 6 months of the date that you got the treatment, they have to submit your charges to your health insurance company. And if they fail to do that within that time period, those charges could be waived, meaning that they wouldn't be able to come after you for those charges. Um, the or part of the statute is if the healthcare company isn't aware that of what your health insurance company is, then it's going to be 6 months from the date that they are informed of what healthcare company you have. So that's one potential way, if you're served with a summons and complaint that says you owe a lot of money for unpaid medical bills, that might be one way that you get the charges reduced if they weren't submitted to insurance properly. So what are some good practices for finding out if this defense might apply to you? The first is going to be you're definitely going to want to obtain bills of the treatment that you got from your healthcare provider. And you're also going to want to get the corresponding medical records for all of those treatment dates as well. Make sure when you ask for the medical bills that you're asking for itemized bills. And the reason this is important is because those bills contain CPT codes, which basically correspond to the medical diagnosis that you got, letting letting you know what the treatment that you're being billed for is. Sometimes they make mistakes with the CPT code that might impact the cost of the treatment. So it's important to at least have that. Um, so another thing that you can ask is you can ask the healthcare provider to confirm and give you documentation of when they actually sent the bill to health insurance, or even if they sent the bill to health insurance, because sometimes they forget to do so. Um, so this is going to be another way to verify whether they've met the requirements of this law. The next step is you're going to want to contact your health insurance company as well. So you can ask them for all the relevant dates of medical treatment that you got. You can ask them for copies of the documents that I've mentioned here. They're called EORs, sometimes called explanation of review, explanation of benefits, health insurance claim forms, or billing statements that they've received. This is how you actually match it up to what the healthcare provider is saying. And then you can really confirm when they actually receive the bill and those kinds of things to know if they're meeting the requirements of this law. Um, I would recommend getting these billing statements and confirming all of those things regardless. Because when you contact an attorney looking for help with this kind of case, it's going to be, really important that you make sure that you already have gathered some of these documents if you're able to do so, because it's going to help them evaluate the case better. And they're going to be much more likely to jump in with representation if they think that there's a potential defense. If it doesn't appear that there's any potential defense, they might give you advice and there might not really be anything they can do because, you can't actually prevent the lawsuit from succeeding because you do agree that you owe that debt if you got the medical treatment and it was billed to insurance properly and all of that good stuff. So make sure, regardless, to do your best to obtain all the corresponding medical records and bills. Another federal law that might present a defense in your medical debt lawsuit is called the No Surprises Act. There's a lot of different, intricacies of this law that would be a lot to explain, and we just don't have the time for it here. But basically, the gist of it is it's meant to address the problem of surprise billing. Now, in order to understand what surprise billing is, you first need to understand what balance billing is. So basically, there's some medical care that you get that's in network and others that's out of network. What does out of network mean? That basically means that there isn't any agreement between your insurance company and your medical provider that you saw for what the insurance company is going to pay them, meaning that they're out of network. So you may end up getting stuck with out-of-pocket payments for that reason. Now, balance billing is basically when you go and see an out-of-network doctor, it's the difference between what the insurance company would pay and what you would have to pay for the costs of that treatment. So what the No Surprises Act is meant to do is meant to prevent in situations where you can't decide whether or not the doctor that you saw is in network or out of network, they want to make it so you can't be charged for the full amount of the treatment. So some examples would be, you got into a serious accident and you had to be airlifted to a hospital, and that hospital is the nearest one to where the accident happened, and maybe they're not part of the coverage network through your health insurance. So it would be unfair because the person that got into that accident didn't choose to go and see an out-of-network provider. And there's other situations where this might happen as well. So we don't want to penalize them with all of this money that they owe when they didn't choose to incur those kinds of bills. It wasn't an act of choice on their part. So that's kind of what the bill is meant to protect people from. So here's just some examples of situations where the No Surprises Act might apply. So when you go to the emergency room, a lot of emergency medical services are going to apply. Um, there's other situations relating to co-pays with out-of-network providers. Um, I think air ambulance transport is definitely covered under the bill. One important caveat is that ground ambulance services are not covered. So that's something to keep in mind as well. Not that people always have a choice of when they're transported to a hospital in a ground ambulance. So, that's just one of those things that I'm sure there was some disagreement when the law was actually passed about what should be covered and what shouldn't. And whoever didn't want ground ambulance services to be covered, didn't succeed in that argument. So again, it's going to be really similar screening for this defense. As the last one, you're going to want to make sure that you get all those corresponding medical records and bills. You might want to also get, copy of any brochures of like in-network and out-of-network, in terms of medical providers with your insurance company. So those are, again, good steps to find out if this law might apply to your situation. I don't think the No Surprises Act would make your medical bills go away. It could significantly reduce the amount that you owe, which might make it easier to actually, recover and pay the debt that you're being sued on. So those are just two defenses I wanted to go into. There's, like I said, many others, and I think we're running out of time here to where I might have to pass it off to the next person. Um, in this last slide, I've included contact information for my organization. So if you're facing any kind of medical debt, we also help with issues relating to, divorces, child custody, housing, other family law, consumer issues like medical debt. So if you're facing any of those, contact information is here on the screen. So feel free to give us a call. We're happy to evaluate the case. And with that being said, I will turn it over to the next speaker, and thank you very much for your time.
Thank you so much, Kevin. That was amazing. I think myself, along with many, many, many other Americans out there and people in our community, probably struggle with some medical debt and not exactly knowing what to do, or even, I mean, like all the different codes and such. We don't think about that, and all we think about is, oh my gosh, now I have a $30,000 bill. What do I do? So there's definitely some questions that popped up. We'll definitely take those at the end. But thank you. Thank you so much for presenting. We're going to go ahead on to our next presenter. Our presenter is Beth Goodall, and she is from Mid Minnesota Legal Aid. And we will go ahead and kick it off to Beth. Oh, and you're muted, Beth, so feel free to make sure to unmute yourself. There you go. All right. Thank
No,
you.
I wasn't sure if you controlled all the muting and unmuting, but thank you. As Crystal said, I'm Beth Goodell. I am the supervising attorney for the consumer unit at Mid Minnesota Legal Aid in Minneapolis. So Mid Minnesota Legal Aid covers 22 counties in the middle part of the state. Our largest office is in Minneapolis, and that office serves Hennepin County. So my work is really centered in Hennepin County, but we also have offices in Wilmer and St. Cloud. Um, a big part of what the consumer practice does, we defend debt cases. So the kind of cases that Kevin was just discussing, medical debt is one type of court case that involves a collection of debt. But we also see more often than any other type of debt collection case, credit card cases, used car debt cases, and miscellaneous debt collection cases. I've seen cases on bail bonds, for example. But credit card cases are the most frequent type of debt collection court case that we see. Often we're not able to provide representation in the court case because of our staffing levels, but also because in I think most of the cases there's not a full-fledged defense to the collection of the debt. We will take any collection case to defend it and represent the person in the case if they have a real solid defense to owing that debt. But a lot of times that's not the case. And so we do give advice only in a lot of those situations. Um, but post judgment, so the end point of a court case will be either a settlement, often, but in a debt collection case, often not a settlement, but a judgment in favor of the debt collector. If we take a case to defend it, we do often prevail and spare our client from having a judgment against them. But a lot of times we see clients who already have judgments against them. So the court case happened. Often the judgment was entered by default because the client couldn't find a lawyer, didn't know how to deal with the court case, didn't really believe they had a defense, and so didn't really try to defend. They come to us post-judgment. Um, a judgment being entered, and I'm not sure if our audience is primarily lawyers or people who are not lawyers, but a judgment entered in a court case is the situation that allows a debt collector to take money, whether you want to give them the money or not. Before they have a judgment, they may call you, write you, threaten you, cajole you, sweet talk you to try to get you to pay them money. But it's when they have a judgment, they're allowed to take the money out of your bank account, take the money straight out of your pay, which is the process of garnishment. And Kevin did mention garnishment, as a real strong reason for trying to avoid a judgment. If there's a medical debt case against you and you have a defense, defend it because, boy, after that judgment is entered, you're stuck dealing with the process of garnishment. So if there's any kind of case that we would never turn away, if our resources for consumer work got down to 1/10 of one lawyer, and we couldn't take anything else, we would still take garnishments because a lot of legal aid clients are able to protect their pay and the money that's in their bank account from garnishment. The primary protection for people, at least in the legal aid income range, is that Minnesota law protects people's pay and their pay once it gets in their bank accounts from garnishment if they have any government benefits based on need. Benefits based on need in Minnesota include MFIP, food stamps, food support, um, energy assistance. I think we don't really have the school lunch benefit anymore because all children in Minnesota schools are now entitled to a free lunch, but a free or reduced school lunch benefit is a type of benefit based on need. But for a lot of people, the benefit based on need that they have is some kind of assistance with health insurance. So whether it's medical assistance itself, which is Minnesota's version of Medicaid, or one of the several options to have some state support for paying your premiums, MNsure, um, those are benefits based on need. And under Minnesota's commitment to supporting families with health insurance, people up to, I think even people beyond the legal aid income eligibility are eligible for support for their health insurance. Minnesota is relatively generous that way. So many, if not most of our clients do have some type of state-sponsored health insurance. If they have that, if a client has that, or if a person has any kind of benefit based on need, including the health insurance, that's a defense to the garnishment. Garnishment starts with a notice to either the employer or the bank. Um, the consumers, the debtors, the judgment debtors do receive notice of a wage garnishment before it starts. So before the employer gets a notice of wage garnishment, the debtor does, giving them a chance to try to head off the garnishment. But when it's a bank garnishment, the bank gets the notice first and the bank account gets frozen. And then the debtor gets the notice that the bank garnishment has started, or they try to access their bank account and can't. So a little bit different timing on that. I think the theory behind that difference is that the creditors believe that if you get a notice of a bank garnishment before the account's frozen, you might empty out your bank account, so you don't get advance notice of a bank garnishment. But either way, the debtor receives notice that either a garnishment is going to happen on their wages or that a garnishment has already begun and their bank account is frozen, and they have a window of time to send proof of their benefits to the debt collector. Once proof of benefits are sent to the debt collector is required to stop the garnishment and return any money that's already been taken. So any money that's already been taken out of the pay or taken out of the bank account should be returned. I've been talking about the content of a bank account pretty broadly. But just to be clear, not all money that's in a bank account is protected from garnishment, even if you have those benefits based on need. What's protected in a bank account is your wages. So once your wages are deposited into your bank account, those wages are protected in the bank account by proof of your benefits, just as the wages before your employer sent them to you. Other kinds of money in bank accounts might not be protected. Gifts that have been given, if someone is helping the person with their bills by giving them money that is now in the bank account, that's not protected. Lottery winnings aren't protected. But most legal aid clients, the money that's in their bank account would be their wages or their government benefits like SSI or Social Security or veterans benefits. Those kind of benefits are protected because they are benefits. They are protected in and of themselves as money, whether, well, it would typically only be in your bank account that those benefits, you're not, they, the Social Security Administration or the state cannot be garnished to take your benefits ahead of time. They're protected as benefits in your bank account. Um, so we do find that most of our clients who come to us with garnishment situations, we are able to help them. We are able to protect their income. And um, I think that other legal aid programs throughout the state would also help with garnishments. I think it's a fundamental type of consumer practice that all of our offices try to have.
Alrighty, thank you so much, Beth. Garnishments is something that I know, I've been working in human services for a long time, and many clients, they do talk about, okay, there's garnishments, there's especially like, well, with child support, but that's totally different. But there's different garnishments that they're going through, and it's really great as the community providers that are on line here today to know what you can do and help out with, and where you can turn your clients over to so that they are able to get assistance. There are some other questions that, popped in for Beth. We will save those to the end. Thank you, thank you, thank you, Beth, so much for telling us. And we'll make sure to throw your website links in the chat so that if anyone has any questions in regards to garnishments, they can reach you if it's something outside of today's broadcast. All righty. We are going to go ahead and jump over to Cheryl. And Cheryl, if you want to come on and talk to us a little bit today, we would love it.
Thank you. And I'm Cheryl Bearish, and I'm actually physically located in Fargo, North Dakota, but I'm licensed in Minnesota and provide legal services, legal work for people who reside in Minnesota as well as North Dakota. My part of the presentation today is really going to be just marketing, I guess, for an upcoming webinar because I'm going to be doing a 90-minute webinar at the end of January that is going to cover information regarding bankruptcy. So when, and the title of the webinar is actually When Financial Crisis is Looming, What Happens for Individuals and Families. And so when people are at the stage where they're going to have money taken from them because there's been a collection lawsuit and they have income or property that a creditor can take from them, that's when it's time to talk to me. There is basic information regarding bankruptcy is that getting a bankruptcy filed stops all collection action no matter what stage, stops a wage garnishment, prevents a creditor from taking money from a bank account by garnishment. And that's the power of a bankruptcy. And people file either Chapter 7 bankruptcies or Chapter 13 bankruptcies. Chapter 13 bankruptcies, the household income is sufficient, so people have an ability to repay some debt in a Chapter 13. So those are higher income households, or they have property they would have to give up in a Chapter 7 bankruptcy. Then there's an option to file a Chapter 13 bankruptcy. Most bankruptcies that are filed are Chapter 7 bankruptcies. It prevents debt collection, and people can keep a certain amount of property. The property that people can keep in a Chapter 7 or a Chapter 13 bankruptcy, usually people are able to keep their homes. So if they own a home, usually they're able to keep it. They have to continue to make payments on a mortgage in a Chapter 7 bankruptcy. There are some options if people are behind in mortgages in a Chapter 13 bankruptcy to catch up with those mortgage payments. Almost always people are able to keep their homes in a bankruptcy, as long as they can continue to make their mortgage payments if they have a mortgage. Everything that people have, if they're to be able to keep them in a bankruptcy, they have what the property they have has to fit in categories called exemptions. And the homestead exemption in Minnesota is very high. It's $475,000, I believe, right now. It goes up occasionally. That's a very high amount. North Dakota, it's only $150,000. And that's equity in a home. So if there's a mortgage, it's the amount that is the equity. In our region of the state, we don't have a lot of those very valuable houses, but there are some out there. Sometimes people inherit property that can have some significant value. So it's important to know that people are able to keep their homes. They can also usually keep a car, most often, and they can usually almost always. You have to have a whole lot of household furnishings in order to not be able to keep everything in your home. And the value of property in a bankruptcy is, if you wanted to sell what you have, what would you get for it? So there are exemptions for household furnishings, exemptions that cover what people have in their homes and what they need to maintain their homes, as far as lawnmowers, things like that. So in most Chapter 7 bankruptcies, most households do qualify for Chapter 7 bankruptcy. People are able to keep enough so that they're able to move forward financially and support themselves and their families. So when someone contacts me and needs to think about bankruptcy, one thing that I do in the preparation for a bankruptcy filing is make sure that they can keep everything they have. If there's something they can't keep, perhaps a camper or some inherited property, then we'll talk about that as far as options, if it's possible to keep that in a Chapter 13 and financially possible for them. But the most important thing to know is that bankruptcy stops the collection effort of a creditor once that bankruptcy is filed with a court. Completely stops. Bankruptcies can be complex. The complexities in bankruptcy isn't just the debt you have. There is also complexities regarding property ownership, potentially, sometimes income information, and all income is counted in a bankruptcy. So when we're looking at household income, child support is counted. So income that's not taxable is also counted. So the reality is that when there's a financial crisis, and when it appears there's going to be a financial crisis, that's the time to contact a bankruptcy attorney and evaluate if debt relief in bankruptcy is something that is needed to protect a household's income and property. So I know we don't have a whole lot of time. This is going to be covered in more detail when I do the webinar at the end of January, but I wanted to let folks know that should there be that situation where there's going to be a creditor who's going to be able to get some money or property, that bankruptcy or debt relief is available for almost every household in some form.
Thank you so much, Cheryl. Bankruptcy is something that, not a lot of people understand all of the different laws about it. So I'm really, really grateful that you came on today. One wonderful thing is, and I'm going to put it on our screen. I shared it for a brief moment, but just so that you guys can see that. Cheryl is going to be doing a CLE on January 30th from 11:45 to 1:15. And she's going to be going a little bit more in depth about bankruptcy. She is donating her time to being able to do this for LSNM, and we are so thankful because we are celebrating Giving Hearts Day this year. And so the proceeds for this CLE training will be going as donations for Giving Hearts Day. So thank you, Cheryl, for helping out LSNM to continue to do the work, so that we can get more attorneys out there helping out individuals. If you do want to register for the CLE, please make sure to go to our website, and then you can go to donate. And when you go to donate, you'll be able to see Giving Hearts Day, and you can sign up for the event there, which is great. Or if you have any questions, on the bottom is my email address so that you can find that there. Let's see, we'll go ahead and stop sharing that. And then I'll put that also in the chat too, so that you guys will have that. The second thing that I wanted to talk about also is when Beth was on, Beth is from Mid-Minnesota Legal Aid. And in January, we also have a tax law CLE that will be going on. And that one, we'll be talking about tax law. We'll have one of our attorneys, we'll have Mid-Minnesota Legal Aid, and that will be our first legal table for 2025, which is going to be really amazing. So please make sure to sign up for that one as as well. We're trying to make sure that we have more CLEs and more educational opportunities because it's really important. Speaking of education, I did want to show you guys a couple of different things. We normally will always have somebody from state support on here to kind of guide us through Law Help MN. And today I wanted to make sure that you guys, if you are working with one of your clients, and I'm going to share the screen here. Okay, if you're working with one of your clients and you have some questions on garnishments, bankruptcy, medical debt, all of that stuff, if you are a Minnesota resident, here's a really, really great option for you to kind of look at some documents with your client. So if you if you were just at lawhelpmn.org, you can definitely go through here and it kind of guide you to show whether you are an attorney or if you're just by yourself looking for document information. But specifically, if you know what you're looking for, go ahead and click on this self-help library. When you go to the self-help library, you'll scroll on down, and on the self-help library gives you some broad topics of the different civil legal assistance that they can provide you. So when you are looking at today's topics, we'll talk about money, debt, and taxes. And on here, if you look at money, debt, and taxes, these are a couple of additional things. So maybe we want to talk about today the debt collection and garnishments, and that's kind of what Beth was speaking on earlier. On here, you'll see different type of fact sheets. So what to do if you're sued, conciliation court. Kevin was talking about conciliation court, your debt collection rights, garnishment and your rights. It gives you some booklets available, and the really, really important things are some do-it-yourself forms. These are going to be very, very helpful for you, and also some different Minnesota websites that you can use. If for some reason you just kind of need to understand it a little bit further, there are some videos available. You can click on Show All and look at additional videos, but this kind of gives you a brief outline of just options that you have and some information that's at your fingertips, so that if you are a community provider or if you are an individual that is looking to be able to get some additional information, this is a great resource. Once you're here, if you're like, okay, I kind of know what I'm looking at and I think I understand it, it's time to find somebody to assist us. We are LSNM. However, there are many different legal services in the state of Minnesota. So if you want to find somebody that's closer to you, feel free to click on providers and clinics. When you click on a provider and clinic, you'll just click on your service area. And once you click on your service area, it'll definitely show you some places that are going to be closer to you. So if you were to click on Outer Tail and you click on search, it should bring you up to wherever the closest legal services or legal aid is going to be. They'll kind of give you some income guidelines, but they'll also go through whether there's an application process, some legal topics, contact hours, and each legal services is going to be a little bit different. So feel free to, and actually I'm going to throw this into the chat. So if you would like to look at it in another time, you absolutely can. I would always put that as a bookmark on. There we go. Put that as a bookmark on because it's a really, really helpful tool. Okay, so now we do have some questions for our members. And if you do have a question, please feel free. This is a great time to throw it in the chat too, so we'll be able to go over those. But our first question goes to Kevin, our LSNM attorney here. And I know stop sharing there. There we go. Is there a particular do-it-yourself form to submit to insurance companies if they're wrong? So I think you were talking about like if you were looking at a EOR, and I apologize, I don't know what I remember the acronym, but I didn't remember what it stood for. But is there a do-it-yourself form or something that somebody would be able to use to start the process?
The short answer is I think it would really depend on which insurance company it is, because every insurance company might have their own individual form for how to go about requesting records. Obviously you can request the records by calling, the insurance adjuster and asking them for them verbally and to be mailed to you. I think maybe a better way would be to do that in addition to sending some kind of written document requesting those records. You're going to want to make sure when you make that request that you're including the dates of service. That's kind of a term of art. Dates of service mean the dates that you got the medical treatment. So make sure that you include all relevant dates of service that you are asking, for billing statements or the EOR's explanation of reviews, like Crystal said, or any medical records. So yeah, it's going to be important that you include the dates, the name of the clinic, you know, other pertinent information. And you're going to want to look on the website of the health insurance carrier to make sure that there's not a fillable form that you should be using for that particular health insurance company.
Perfect. And so I have one other follow-up question on that. So say if you do request this EOR and if the insurance company doesn't provide this, then what should you do? Like, you're asking for these explanations and they're like, oh yeah, they didn't provide this stuff in the appropriate amount of time. Where do you go next? What's your next step?
I mean, that's kind of tricky. Off the top of my head, I'm not sure if there's any kind of penalty for them refusing to provide those documents. I know that they're required to send them to you, when they decide the insurance claim. So, obviously the way it would work is first the healthcare provider sends the bill to the insurance company, and then they have to make a decision on that bill within a certain period of time as well, whether it would be denying it, accepting it, and or paying it just in part and then leaving some to out-of-pocket payments. Um, but it does get tricky when an insurance company refuses to provide that information. Some of them have an internal grievance procedure. So that's something to look into when you're speaking to the insurance agent. You can always ask to speak to their manager, which sounds a little cliched, but if they're not providing you the information that you're looking for and you're being respectful and asking them nicely for that, then it might be time to go over their head so you know that whether or not you're going to be able to defend the lawsuit.
That's perfect. No, thank you for that because I think sometimes people get stuck where they have the information and it's like, okay, well, what's next? So we always want to make sure that we know. So thank you for that information. I'm going to go over to Beth and I did have a question here. So let's see. If you have government benefits and someone wants to try to garnish that, is there a self-help form that they can fill out to stop a garnishment? Or like how can you show proof of benefits? What do you do?
So the packet of documents that the debt collector has to send at the beginning of a garnishment includes an exemption claim form. It's, I think, 3 pages long, and it's in the middle of a set of documents that's probably 15 or so pages long. So it's not always simple to find it. Um, but it is a form that is intended to be filled out by the debtor and signed. It has a checklist of benefits that if you have them, having those benefits would protect your wages, either at your employer or in your bank account. So you check off the benefits that you have, sign the document, and mail it with proof of your benefits to the debt collection lawyer. If it's a bank garnishment, you're also required to send 60 days worth of bank statements because the creditor has the right to see what's in the bank account. And it's 60 days worth of statements because your wages, once they're in your bank account, they're protected for 60 days going forward. So you get paid, and let's say 30 days later, there's a bank garnishment, the pay that's been in there for 30 days is still protected. If you still have some of your pay left in your bank account after 90 days, you could lose that pay in your bank account to the garnishment. But again, it is a self-help form, but it is required to be sent at the beginning of every garnishment.
Thank you for that. No, that's really important. I think sometimes people get scared and they see the envelope come in and they know what's going on and they don't open it and then they're missing out on their opportunities. So definitely open your mail. That's probably a really good
Yeah, I
steps.
do feel like it's a pretty straightforward process. Just I think if you sent the proof of your benefits without the form, the debt collection company would probably stop the garnishment, because they know you have the benefits. But it is a straightforward process, but people are intimidated by it or they miss the notification. And so that's why our services are important for helping people, even with a process that there's, the idea is you're supposed to be able to do it yourself.
Absolutely. No, thank you. Thank you. Thank you. And our next question, our last question here is going to go to Cheryl. And so like for the question that we have is, so let's see, where do you find the exemptions for things that you can keep in your home? Is there a website or is there a court docket of some sort? Where would you find these forms so that they know, okay, if I'm going to go and have a bankruptcy, I know exactly what I'm able to keep? And I think you touched on it a little bit, but just so that the audience can find it.
It doesn't exist in a format that would make sense to people. And that's because in Minnesota and bankruptcies, there are two kinds of exemptions that are available. There are federal exemptions that are part of the federal statutes, and there are state exemptions. And I've been preparing my presentation for January 30th, and the information I have is that it's complex, and it just flat out is complex. I'd have to look. I'll make a note for the January 30th presentation to see what's available on the Minnesota Bankruptcy Court website. But because there are two options for what people can keep, and because it varies based on which state people live in, like in North Dakota, the federal exemptions are not available. We have to use the state exemptions. It is a significant part of when I'm working with someone on the process of filing a bankruptcy, it's a significant part of what I do. Under the Minnesota statute exemptions, I'd have to look at that Law Help Minnesota guide to see if there's a resource there regarding what the Minnesota state exemptions are, to see if that's available. And then the difficulty is in Minnesota, they just changed them in the last legislative session. And some of the Minnesota exemptions are only available in a bankruptcy, not in state court collection actions. So they made it a little more complex also. So that's an answer that says, I wish it were easy, but it's not, unfortunately.
No, but that brings up a good point, though. Although we talk about money and debt in Minnesota and the garnishments, the bankruptcies, the medical debt, having somebody on your side to be able to get you through these issues is dire. It's important because there's sometimes some little steps that you miss and it could help to save you thousands of dollars. So having somebody that's going to be able to look at those bankruptcies, look at those medical codes, look at the garnishments and ways that they can help you. It's really, really important that you come to the professionals to be able to help you out. And a lot of the times, whether you're low income or you're not low income, there are different self-help guides. There are different legal professionals that can help you. So with that being said, we want to just make sure to keep on time because I'm trying to respect everybody's time. I want to thank all of our presenters today for coming in, for
Before
allowing
you
us. Yes,
continue, I did, as you were talking, I apologize, I was doing two things. I did
No, that's okay.
check that self-help website, and under the section that's on debt collection, there's a part of it that's your debt collection rights. in
Oh,
there.
perfect.
And under your debt collection rights, there is, can my house or vehicles be taken to pay a debt? And there's some information there regarding the homestead exemption and the vehicle exemption. I don't see that it continues on to household furnishings, but there's some information. So if I drill deeper into that website, there might be some information there that provides that reassurance as far as what is protected against creditors. And then just a quick note, a question I often get is how do people pay? Because I'm a private attorney, how do people pay for getting a bankruptcy filed? It's because they stop making payments on the debt that will be included in the bankruptcy discharge. So many people are trying to pay debt. And so the question becomes, well, my money is all going to my household living expenses and to trying to pay the debt. How do I pay you? Bankruptcy stops debt collection. They can stop making payments on the debt that will be included in the discharge. Credit cards, medical debt is almost always dischargeable debt. That's how they pay for the costs of the bankruptcy, and most bankruptcies are flat fee. So, sorry.
No, that's good to know because you know what, I didn't even think of that question. A lot of times we're working, well, I'm in the legal aid realm where a lot of people's services are free. So it's really good to understand that, you know, there are ways and there are options. And if you do want to know more about bankruptcy, which now I definitely want to learn some more, please sign up for our CLE. Not only are you getting a 1.5 standard CLE, but you're also helping out for Giving Hearts Day. So it's a 2-for-1, which is great. If you do have questions on that, I'm going to just provide my information here. I'll share that on the screen. Feel free to send me an email. Feel free to call me, or if you would like to book a time to just kind of talk about any of the different presenters that are here today so that I can connect you if you would like, or if you would like to be a presenter for 2025. Our legal table will be going for every other month for the for 2025 so that we're able to bring you some more CLEs, and a lot of different educational opportunities, and our justice bus will be doing a lot more rolling around this year. So please stay tuned. I want to thank everybody so much for joining us today. Thank all of our presenters. If you do have questions, feel free to reach out. Other than that, we will probably just head out just 2 minutes early today. And that's all we have for the legal table. Thank you guys for joining us, and hopefully we'll catch you either January 30th for the bankruptcy CLE or January 21st for our tax law CLE. Thanks again, everyone, and have a wonderful afternoon.
Thank you,
Thank
Crystal.
you.